With that, as it were, back to the murder issue. The first accused person was arrested, subjected to an identification parade. It is the evidence of the prosecution that he was identified by 3 witnesses. Subsequently, the second accused person was also arrested. And according to the prosecution case, she was arrested because, 1, she was within the vicinity of the commission of the murder. According to the prosecution, the vehicle that was used in the commission of this offense was hers. According to the prosecution, she aided and abetted the first accused person by providing that vehicle. According to the prosecution evidence, she switched off her phone at the time when the offense was being committed. According to the prosecution case, she gave false information to the police about the shooting incident, and the intention was to divert their attention from investigating the murder charge. And finally, according to the police, she aided and abetted and or was aware of destruction of the evidence that will be used in the murder case through the burning of the items that were recovered, believed to have been the items used in the commission of the murder and eventually destroyed. In a nutshell, that was the prosecution case. Case, each accused person was placed on their defense after the court found they had a case to answer. The first accused person gave a sworn statement in his defense and testified to the effect that he works as a security consultant, and that on the 19th day of September 2018, he dropped the second accused person at work at 8:05 a.m. and returned home at Royal Park Estate in Langata. It was his evidence that he stayed at home until about 3 o'clock when their house help notified him that there were people from Kenya Power and Lighting who had gone to attend to an issue at the house. And so he went to attend to them, and that was that. It is his evidence that he eventually, excuse me, that he left the house at 4:30 p.m. to a place known as Roadhouse along Dennis Pritt Road, where he arrived at 5 p.m. He met a friend by the name of Jennings, who testified as prosecution witness number 8. According to him, after their conversation, they went looking for fuel for his vehicle, got fuel. He dropped Jennings back to pick his vehicle from where he had left, and he, the first accused person, proceeded to join the second accused person at a club in Westlands described as Club 40. It is his evidence that they left the club at 4 a.m., drove home and slept. That the following day, which was the 20th day of September 2018, he dropped the second accused person at work and then went to pick her at 8 p.m. After and before they left, a quarrel ensued between them, which spilled to home. And when they got home, the second accused person threw his things out of the house. And as he was extremely drunk, he didn't realize that he had a gun. His gun went off and injured him. But the gun was not his. It belonged to his neighbor by the name of Brian Kasaine Spira, PW 17. And so he rushed to Brian's house and told Brian to go and secure the gun. Brian went secured the gun and assisted him to go for treatment. He was taken to Langata Hospital. Langata Hospital referred him to Nairobi West, and eventually he ended up at Kijabe AIC Hospital for admission and treatment. He was later arrested, taken to his residence. A search conducted, several items picked up, and he was charged. In a nutshell, that was his evidence. As already indicated, the second accused person gave evidence through an unsworn statement. May I draw us to the provisions of Section 213 of the Penal Code, which is very long and which I've made a general reference to. And so it provides the circumstances under which the cause of death may be inferred and proved by way of circumstantial or medical evidence. And in that regard, allow me to draw your attention to the case of Benson Gunyi versus Republic and request that you look at it later. In support of the prosecution case as to what caused the death of the deceased, the prosecution called the doctor who performed a post-mortem on the body of the deceased. And this is what the doctor said, that he made an observation. It was a body of a female aged about 28 years. It was wrapped in a blood-stained wet maroon and white bed cover. Both hands and right leg had henna tattoos and sealing straps. On examining the body externally, he noted that there was an irregular, invasive wound, interior neck, measuring 7 by 6 centimeters, with visibly slit trachea and airway. That there was blood oozing from the nostrils. The body was pale, an indication it was lacking blood. He saw contusions on both wrists and bruises around the wrist of both legs. Internal examination revealed that the airway had been shot through and through. The trachea had been transected at the level of thyroid glands, and the right carotid artery on the neck and right jugular vein had been severed. The doctor says that means cut through and through, and there was blood oozing from her private parts. So the doctor formed the opinion that the cause of death was exsanguination due to severe neck injury due to sharp force trauma, and that the probable weapon used was a sharp object. So based on this evidence of the doctor, it is the finding of this court that the prosecution have proved that the cause of death of the deceased. Okay. The third element was lawful or unlawful. Article 26, Article 3 of the Constitution of Kenya states that, excuse me, a person shall not be deprived of life intentionally except to the extent authorized by the Constitution or the written law. We all know that if a death sentence is applicable and the court makes an order that you go and suffer death, yes, you are entitled to your life, but once the court makes a finding, then you fall under this provision as an exception. So the question one would be asking is, now that we have established the death occurred, and what caused it, then was that death lawful? In addition to, say, Article 26, may I draw your attention to the case of Gusambizi Wesonga versus Republic 1948, where the court said this: every homicide is presumed to be unlawful except where circumstances make it excusable or where it has been authorized by the law. For homicide to be excusable, it must have been caused under justifiable circumstances, for example, in self-defense or defense of property. Pursuant to these provisions and in my own understanding, I find that excusable homicides are killings which result from accident or inadvertence or done up by a person who lacks capacity to commit an offense, such as a young child or a person who is legally insane, or in any reasonable defense to self or property. In the instant matter, Dr. Njenga did not testify to any circumstances that would amount to excusable homicide. In cross-examination of the doctor by the defense counsel, he stated that there was no evidence of strangulation, nor a gun or bullet wound, and there was nothing unusual in the pancreas, indicating that the blood that was oozing from the nostrils was because the throat was slit at the level of the thyroid glands, and ratified that the wound would not have been inflicted after the death, because a person does not bleed after death, as it is the heart that causes the bleeding. Pursuant to the evidence of this doctor, it is the finding of this court that the deceased did not die of an accidental or natural cause. The death was not accidental, it was not an unnatural death. Therefore, this is a clear case of homicide that falls outside the excusable homicides. And so, the finding of this court that the prosecution have proved that the death was unlawful. And so the next issue to determine is whether each or both of the accused persons are the ones who caused the death of the deceased. And then finally, we'll be answering a question: if they did they have malice aforethought? Because you can cause a death, but you didn't have malice aforethought, and of course, that may be manslaughter. We are dealing with death. So they need not just to prove that they committed the offense, but there was malice aforethought. I have chosen to take the path of looking at the evidence that relates to the first accused first in relation to that issue, and then go to the evidence relating to the second accused person for ease of understanding and flow of the judgment. And so right now, I'm analyzing the evidence the prosecution have adduced in answer to the question as to whether the first accused person caused the death or killed, bluntly put, the deceased. Under this particular issue, I have discussed several items just for understanding of the parties. And let me just mention some of the items that fall under this. There is the issue of identification parade. There is the issue of the clothes which the accused person was wearing. There is the issue of a stolen ID card. There is the issue of destruction of evidence. There is the issue of the gun. And so I will try and flow the issues in what I believe is a chronological manner. Again, for ease of understanding. Now, if I may fast track us, I have, in answering this question, which is a very critical question and very critical part of the judgment, summarized the prosecution's submissions, summarized the victim's family submission, and summarized the first accused submissions. And Professor Nanda treated me to good substance, not good in the sense that none of the other people's substance, but in terms of volume. So a bit of this judgment, which I think runs into about 30 pages of 35 pages, is really a summary of what the parties submitted, okay? But I would like to read it out in brief for us to know. And so, the prosecution, of course, advanced their case that the first accused person killed the deceased. And they did that by inviting this court to look at the conduct of the first accused person before, during, and after the murder. And inviting this court to do that, the court was invited to note the following, that one, before the murder, it is the prosecution case that the first accused person stole the ID card of Dominic Becerra Harun and went to use it to access the residence and the premises where the deceased was staying. That is the submission of the prosecution. It is the submission of the prosecution that the first accused person had extra cloth changed into those clothes, went to the deceased house, committed the murder, changed out of those clothes, and that's it. It is the prosecution case that the first accused person armed himself with a gun to the deceased house to use it to subdue, to intimidate, to coerce her to submit before the murder or in the course of the murder. It is the submission of the prosecution case that after the accused person, that is the first accused person, had committed the offense, he went and destroyed the cloth, which would have been used as evidence in this case. It is the prosecution case. He then shot himself to divert the attention of the investigators from investigating the murder charge to investigating a shooting incident. The family of the deceased concurs and associates themselves with the prosecution case and invites this court to note that the evidence by the first accused person that he did not know the deceased is insincere. And they draw the court's attention to the fact that there is call data that speaks to the contrary. And the family of the victim submitted to this court that it should take cognizance of the fact that motive is irrelevant for purposes of proof of the offense of murder. What did the first accused submit on? The first accused persons have submitted that the description given by the prosecution witnesses on the clothes that their first accused was wearing is generic in the sense that those clothes did not have any marks that would identify them specifically out of any other clothes of the same kind. The first accused person has submitted that there was a lot of contradictions in the prosecution witnesses' testimonies. I have analyzed what they are inviting this court to consider as contradictions, and they are as follows. One, that there are contradictions on the time when Haron entered the deceased house and left. And that saying those contradictions arise from the record held by the protected witness number 3 and the guard at the gate that shows that Haron entered the deceased house at 23:21 and left at 23:31. And therefore, that suspected killer was in the deceased house for only 10 minutes. And they are submitting, is it possible to commit a murder in 10 minutes of this kind? They have submitted that the person whom the court is being invited to deem as the first accused person and who has been identified as Haron is not the first accused person. That the prosecution have failed to show the nexus between Haron and the first accused person. They have invited this court to look at the contradictions as they relate to the evidence of the witness number 8, Jennings, that the first accused person had a bag in which he carried a white counsel when all other witness evidence and the evidence of PW10, George Kimani, the brother of the deceased, is that he is known to the accused person because they were together at Kenya Polytechnic. As far back as, I think, 2002, they were in the same class, taking the same course in hotel and beverage management. It is the evidence of that witness, please mark the date, on 31st of August 2018, he was with the first accused person in the house of the deceased. The death hearing was on allegedly unknown time, said to be 19th of September. But I am saying, and I said, please mark the date. This witness, the brother of the deceased, says, prior to the death of my sister, on 31st of August 2018, I, my girlfriend, the first accused, and the deceased were in the deceased's house. Ramuria Gardens, same apartment. And that the sister, the deceased, mentioned to him that she was communicating with the first accused on Instagram. That on the material night, the first accused person and him slept on the sofa set, otherwise known as the couch, whereas the deceased and the brother's girlfriend slept. And I'm not saying this for no reason. Everything I say has a reason. Slept on the deceased bed. It is also the evidence of George Kimani. On 19th of September, the deceased sent him a screenshot of a conversation between her and the first accused. And that conversation was to this effect. The first accused was telling the deceased that when he returns from Mombasa, he would go and see George Kimani, that is the deceased brother, for a drink. and that the deceased was telling the first accused person, don't spoil my brother. 19th of September. My observation from the evidence is that this evidence of George Kimani, that on 31st of August 2018, he was in the deceased house with the first accused person, was not disputed through cross-examination of the witness by the first accused person. And I'll tell you why. This was the nature of cross-examination by the first accused person. I quote, "The deceased was communicating with Jowie, but she didn't describe how they were. I believe they were friends. There is a night we spent with the first accused in the house of the deceased. We were all happy. I slept on the couch. I woke up in the morning. The first accused person had already gone. When I woke up, I was not very drunk. I wouldn't know what the first accused person did with my sister when I was asleep. I don't know whether he was another man in my sister's life. If he was, I would have known. I did not know Papa. My analysis of this cross-examination does not lead to an accused person denying that I don't know the deceased." Brian Kasaine Spira, corroborated by the evidence of no other person than the first accused person himself, is that by 19th of September 2018, the first accused person was in possession of a gun. That gun belongs to Brian Kasaine Spira. And so, it is undisputed that on 19th of September, the first accused person was in possession of a gun belonging to Kasaine, PW17. In fact, Kasaine testified that the first accused person had earlier on borrowed this gun to go on what he said a refresher training, returned it, and then he borrowed it again. And according to Kasaine, and this is important, he was supposed to return that gun after 2 days, but he didn't. And so, by 19th September, he had a gun. That corroborates the evidence of Jennings that when they left Roadhouse, the first accused person opened the dashboard of the car and removed the gun after putting a white council on top of his clothes and picked a taxi and went where he was going. And so the question is this: if he was armed with a gun and the gun was not used to kill the deceased, what was it for? I am in concurrence with the submissions by the prosecution that the gun was intended and used for the purposes of subduing the deceased. I'll quickly move to the identification parade. The identification parade was conducted by Chief Inspector Arama. Again, I'm fast tracking, so I'll not go through the rules of a parade. There were witnesses when I looked at the identification parade, and critically so, I noticed the following. One, the identification parade listed 4 witnesses who I do not understand how, but anyway, is there, included the investigating officer. But the investigating officer then was not given an opportunity to go to the parade, but he's indicated as a witness. As I told you, I looked at each and everything that I needed to look at. And the identification parade form has a provision where a suspect is supposed to indicate whether he or she is satisfied in the manner in which the ID parade was conducted. According to the Inspector Araman, who testified as PW28, the first accused person was satisfied that the parade was well conducted. However, it is notable that the first accused person did not sign on that form where he was supposed to sign to confirm that he was satisfied with the parade. Secondly, it is in evidence that PW7, and he admitted Owen, before he went to the identification parade, he had seen the photograph of the first accused person. And so that then must have aided and abetted him to quickly pick up the first accused person from the parade. Thirdly, whereas the officer who conducted this parade, who is Inspector Araman, says that the first accused person was not in a sling, contrary evidence has been given by the prosecution witnesses, including the protected witness. And so, the contradictions can only go to the benefit of the first accused person. And in just emphasizing on the need to conduct a proper identification parade and for the benefit of the office of the DPP, join me in the words of the court in David Mwitawanja and Others versus Republic. Quite good read on identification. And this is what the court said. The purpose for and the manner in which identification parades ought to be conducted have been a subject of many decisions of this court over the years. And it is worrying that officers who are charged with the task of criminal investigation do not appear to get it right. As long as 1936, I don't know whether anyone of us was there, the predecessor of this court emphasized the value of identification as evidence and would depreciate considerably unless an identification parade was held with scrupulous fairness and in accordance with the instructions contained in the police force standing orders. They made reference to the case of Ara versus Mango. And so, the court says this: it is not difficult to arrange a well-conducted parade. The orders are clear. If properly conducted, especially with an independent person looking after the interests of the suspect, the resulting evidence is of great value. But if the parade is badly conducted and the complainant identifies a suspect, the complainant will hardly be able to give reliable evidence of identification in court. Whether that is possible depends on clear evidence of identification. I will not finish the quote. It is the finding of this court that the manner in which the parade was conducted was fraud. And therefore, this court cannot find the first accused person guilty of the offense he's been charged with based purely on the evidence of the identification parade per se.